The three-judge panel, established by the Tennessee General Assembly and selected by the Tennessee Supreme Court for this particular case, will now transact the business for which it was created. All persons having business before the court, draw near, give attention, and you shall be heard. God save the United States, the great state of Tennessee, and this honorable court. The Honorable Ann C. Martin, Tammy M. Harrington, and Valerie L. Smith presiding.
We are here in the consolidated matters of the Metro Government of Nashville and Davidson County versus Tennessee Department of Education and Roxanne Mcewen versus Bill Lee.
Good morning. I'm Chancellor Ann Martin. I'm the presiding judge on the three-judge panel, and I'm serving on this case along with Judge Tammy Harrington and Judge Valerie Smith. Can you all see and hear us okay? Yes, generally, nods, thumbs up, okay. So what I'd first like to do is find out who all we have on the call and who is representing whom. I know we did this last time when we had the case management, but it is helpful for us to identify who is on. So let me first ask, representing in the 20-143 Part 2 case, representing Metro Government of Davidson County and Shelby County, who is here for those parties?
Good morning, Your Honors. I'm Allison Bussell. I represent the Metro Government of Nashville and Davidson County. I also see on the screen Lee Whitwell, who represents Shelby County, but I will be arguing for both of the plaintiff counties today.
Thank you so much. On behalf of the Mcewen plaintiffs in 20-242 Part 2.
Good morning, Your Honors. Christopher Wood on behalf of the Mcewen plaintiffs, and I have with me as well Stella Yarborough, Sophia Hill, Wendy Lecker, and Jessica Levin as well. I will be presenting the argument today, Your Honors.
Thank you so much. And then on behalf of the state in both cases.
Good morning, Your Honors. Stephanie Bergmeyer from the Attorney General's Office, and Jim Newsome is present as well.
Thank you. And then on behalf of the BAW interveners.
Good morning, Your Honor. Keith Neely on behalf of the BAW interveners, along with my colleagues David Hodges and Arif Panju. I will be arguing with respect to the Metro plaintiff's motion for a temporary injunction, and my colleague Mr. Hodges will be arguing with respect to the Mcewen plaintiff's motion.
Thank you. And on behalf of the Greater Praise interveners.
Good morning, Your Honor. Brian Kelsey on behalf of the Greater Praise intervener defendants, and I will be arguing the county's claims this morning. You have before you, and please tell me if this is not the correct time, but you do have before you a motion pro hoc vice for my colleague who's with me, Mr. Riley Stevens, who, if you are willing to grant that order orally, and we did present a written order, then he would like to argue the Mcewen claim.
Thank you, Mr. Kelsey, and I have next my list of 4 procedural motions that are pending, and I'm sorry we didn't get that order entered earlier, but I hoped it would not prevent Mr. Stevens from being prepared to participate and appearing. So thank you for that. All right, any other lawyers on the call representing any of the parties?
Your Honor, this is Marlene Iverson. I'm the Shelby County attorney.
Okay, thank you, Ms. Iverson. All right. We have 4 preliminary matters that are pending, as Mr. Kelsey raised, 3 motions filed by the Greater Praise interveners and 1 filed by a purported amicus group. Let me go through those and announce the court's rulings, and orders will be entered on these. The Greater Praise interveners filed a motion for pro hoc admittance of Riley Stevens as counsel, and that motion is granted. An order has been submitted and is probably being electronically filed as we speak. The next motion is the Greater Praise interveners motion to strike the Mcewen plaintiff's reply. That motion is going to be denied, and the court will enter an order reflecting that. The third motion that is pending is the motion by the Tennessee Education Association, the Metro Nashville Education Association, and the United Education Association of Shelby Counties request for leave to file an amicus brief. That motion is granted, and a proposed order has been submitted and is being filed. The fourth motion that is pending is the Greater Praise intervener's motion to file a reply, and that motion is denied, and an order will be entered to that effect. I believe those are the four motions that are pending that have been filed the last couple of days, and those orders will be entered so that the court's ruling on that is clear. So we will move to the temporary injunction motions that are pending. What the panel has decided is that we will ask the Metro Shelby plaintiffs, or sometimes referred to as the county plaintiffs, to go first and present their motion. We will then ask the Mcewen plaintiffs to present their motion. I recognize that they are proceeding under two different legal theories, but it seems to be the most efficient to have them go at the same time. Then we will invite the state to respond to those arguments, then the BA interveners and the Greater Praise interveners. And if the parties are sharing argument, it is perfectly fine to go ahead and share that, however that breaks according to your preparation during your presentation. And then we will go back and give the county plaintiffs and the Mcewen plaintiffs the last opportunity to address the court, since these are their motions and they have the burdens of proof in this case. The judges will ask questions. This is a little bit awkward doing this via Zoom, which is why it is not our preferred format, but circumstances and timing have necessitated such, so we will all just do our best not to speak over each other, and we will, the judges will interrupt as needed and just assume that we'll all respond accordingly. All right, so I would invite Ms. Bussell to begin on behalf of her clients.
Thank you, Your Honor. May it please the court. The court should enjoin the state defendants' implementation of the ESA Act, the Education Savings Account Pilot Program, under the temporary injunction standard in Tennessee Rule of Civil Procedure 65.04. I'm sure the court is familiar with the factors that courts consider in analyzing whether to grant an injunction, but those are, first, the likelihood of success on the merits, whether the movement can establish irreparable harm in the absence of an injunction, the balance of harm to the parties, and the public interest. I will address each of those, but not in the order I just described them. I'm actually going to start with irreparable harm to the plaintiffs. Irreparable harm is established here in two ways. First, a constitutional violation, as is alleged in this case, necessarily establishes irreparable harm. Now, I will address likelihood of success on the merits in a bit, but when constitutional rights are threatened, irreparable injury is presumed under the case law. U.S. Supreme Court case law, Tennessee Supreme Court case law, all of the case law. And this is particularly true if monetary damages are unable to make the plaintiffs whole. Here, damages cannot make the plaintiff counties whole for a variety of reasons. In fact, money damages aren't even available against the state in a constitutional challenge case. The state defendants want to roll out a brand new, undeveloped ESA program at the beginning or even in the middle of a school year. School starts Monday. School budgets are set, plaintiff counties' budgets are set, and school operations are well underway for the new school year. Based on those already established budgets, staffing and operational structures are in place and ready to go for students to arrive in just a few days. But the TDOE plans to take millions of dollars from Shelby County and Davidson County's LEAs to fund private school tuition. At $8,684 per ESA, that's $43 million that MNPS and SCS will collectively lose if the program has full participation. That's $26 million collectively if only 3,000 students participate. Now, defendants argue, well, fewer students means fewer costs, but it actually doesn't work that way, especially when there isn't any turnaround time to plan for it. Not simply reduce costs in proportion to the number of students that leave. Organizations might increase efficiency as they upsize, but it actually doesn't work the same way in the opposite direction. When 4 students leave a school or 10 students leave another school and 18 students leave another school, those schools still need the same number of teachers. They need a librarian, they need a principal, they need functioning copy machines, and they need money to keep the lights on. Students' lives are affected when their schools no longer have the money that they planned on having to pay for supplies and salaries.
Ms. Bussell, can I ask you a question? I'm sorry to interrupt so early, but this brings up an issue I've been thinking about. I appreciate that sort of ultimate reality of if this plan goes into effect, that's going to happen. But how is that different or unique to the timing of the program being ramped up so quickly? I mean, whether the program was put into place 15 days before school started or 3 months before school started, that impact was going to be the same, wasn't it?
That's a great question, and I would respond in 2 ways, and I'm writing them both down so I don't only address one of them. So as to the timing question, the impact on the school districts is actually very different from a timing perspective, and that's because there was no ability to pre-plan for it. Now, because if this program was enjoined until just a couple of weeks ago. And the Supreme Court only recently ruled right at the end of last school year that the Home Rule Amendment claim was not viable. That claim had been viable through 2 levels of court before that. And so given the timeline that was set forth in the state's filings at the initial injunction stage, the counties had no reason to believe that this program could be put into effect in a mere 3 or 4 weeks like the state is now contending it can. If there was any plausible expectation of that happening, then presumably the school districts could have asked for more money in their budget to cover that gap. And then the counties, of course, would have to make the difficult decision of, do we fund that? Well, if we do, then we're effectively just shifting that injury to the counties, right? Because they both have to pay for the program on the front end so the school districts don't lose all of this money without the ability to account for it. And then, of course, they're locked in. They're locked into that funding amount as a result of the maintenance of effort requirements in state law. So from a timing perspective, it's really harmful to the LEAs because they couldn't do anything to get more money in advance. And then from a legal perspective, it's harmful to the counties across the board, regardless of when it's implemented, because they are always the entity that is footing the bill for the program. And in fact, Your Honor's question was a beautiful segue to my next point, which was, claiming that plaintiff counties can fill the gap later. Because again, budgets are set. The county would have to make a supplemental appropriation to provide to close that gap, so to speak, regardless of how big it is. And again, if they make a supplemental appropriation out of regular operations, then they have to fund at that amount going forward, because of the maintenance of effort statute. If they don't fill that gap, then they suffer the political consequences of that, of course, but they still have to keep paying for those same students every year. And we'll talk more about this at the likelihood of success prong, but the injury here, it's very important because I think the defendants are missing this. The injury is not just loss of funding. The injury is the classification contained in the statute. It's not that you're taking Davidson County money or Shelby County money alone. It's that you're taking Davidson County money and Shelby County money and nobody else's money. Everybody wants to talk about the charter law. Well, the charter law applies statewide. You're not taking money from districts in Davidson County, but not Jackson, like you are under this act. So it's an equal protection claim. It's the classification that causes the constitutional injury when that classification is not properly tailored to the requisite governmental interest. LEAs are non-revenue generating, and that is sort of the main point that the counties are trying to make here. School districts don't get money on their own, short of a PTO or a booster club. The counties have to fund them, or the states have to fund them. And in the case of Nashville, it's predominantly the counties that fund them. So when they take money from the LEA to pay for this program, they are necessarily taking county money every single time. And then any shortfall becomes the county's problem. Either fill the gap, or the school district is harmed and the students are harmed and the taxpayers are harmed, or pay more money on the front end, keep counting them and pay more money on the back end, or you suffer the political consequences of that. But once you pay that money, you're locked in. You're locked in at that rate. So the counties are always going to be injured under this program, and that is by design. The General Assembly did not want the state to have to pay for this bill. The state's not paying a penny more than it would pay if those students remained in public school. The counties are paying for them on the front end, and they're also having to count them every single year after that. So to say that the harm is only to the school districts is to completely misunderstand school funding law. Now, Greater Praise says, well, technically, the counties don't fund ESAs because the county doesn't actually give the money to the ESA, it gives the money to the school district. And then they take the money from the school district to put it in the ESA. That is the functional equivalent of saying that a teenager paid for his own date when dad gives him a 50 when he's walking out the door. It's still dad's money. And at the end of the day, the counties are always funding the school district. It's the county's money, and they're required by law to fund the school district. So that is really just kind of shuffling shells around, but we know that the local government, the local county is the heart and soul of this program. Without the county's money, they have no program. Greater Praise also claims that if it's compensable, if the injury is compensable with money damages, then there's no irreparable harm. Again, two problems with that argument. Money damages are not available against the state of Tennessee in a constitutional challenge case. I feel quite confident that Ms. Bergmeyer would have asserted sovereign immunity if I had attempted to include a money damages claim in our complaint. And the other reason that claim fails is because the money damages don't actually alleviate the harm. As I described previously, when the school district's money is taken on the front end, that is in and of itself county money that is being taken because they get their money from the county. And then when the LEA, the school district, has to count those students as part of its enrollment, that means that the county then has to pay for those students' attendance as if they never left the public school system. And that concept doesn't exist anywhere in the state of Tennessee except Davidson and Shelby County. If a student in Franklin decides to leave Franklin High School and go to BGA, Franklin, the county, Williamson County no longer has to fund that student's education. But in Davidson County, if a student leaves Hume Fogg High School, the best high school one of the best high schools in the nation, because they certainly qualify to get an ESA if they meet the monetary requirement. When that student leaves Hume Fogg, Davidson County still has to fund the school district for that student. So money damages won't make the plaintiff counties whole because they've got to keep funding these students forever, and they're being treated differently than other counties when they have that requirement. The harm here is also exacerbated because of the way that the TDOE is rushing out this program. And there's a couple of very specific ways that this is happening. First of all, they're doing it so quickly that they are completely ignoring the requirement in the statute for establishing education savings accounts. That's the name of the act, the Education Savings Account Pilot Program. But what they have currently proposed for this school year, again, because they don't have time to go procure contracts, that takes time, and they don't have time to do that. And so if they're going to get this thing up and running in the next few weeks, they're just going to have to write checks directly to private schools.
And let me ask you about that, Ms. Bussell. And I have a list of irregularities or items that Metro raised and Shelby County raised in their briefs that I want to ask the state about in terms of what the statute says and how it's being rolled out because of the timing. But how does that really impact the injunction request and the ultimate either, claim of irreparable injury or the ultimate constitutionality of the program? I mean, if the state rolls it out and does it irregularly or doesn't follow the statutory provisions, or it's a mess or a problem or something happens, then that's one thing, but that doesn't necessarily make the statute unconstitutional, and it doesn't necessarily enhance or create a legal problem that justifies an injunction. That's what I'm trying to get my head around.
Sure. Well, now we, of course, in our amended complaint have asserted a count 3 directly alleging ultra vires action, that they just simply do not have the authority to do it in the manner that they're now proposing. I completely understand that that's not before the court, but I did at least.
And we got that yesterday, I think.
Yes.
Yes.
You've gotten a lot of things this week. I certainly do not expect you to have read that yet. But I just wanted to flag that for the court. I think with respect to the irreparable harm, the point here is this is a constantly changing dynamic that the plaintiff counties are having to figure out, that the LEAs are having to figure out. It is a moving target. Just this morning, in fact, the application is live. I don't think it was there yesterday, but it is there today. This is a constant moving target. And despite that, we plaintiffs have been given virtually no information about how this is actually going to impact us. I think they're trying to roll out information to tell people who might want to participate how it could affect them, but there's been no information provided about how administratively this is going to affect the LEAs. There are potential testing costs outlined in the fiscal memo that just everybody's ignoring. Nobody's told us how that's going to affect the counties, because of course, we pay for the school districts, or how that's going to affect the people actually running the schools. And then I would say with respect to Shelby County, it's actually worse. When you take a look at the BEP allocations for this upcoming school year, which we've supplemented in a notice of filing, unless my math is bad, it looks like Shelby County is actually required to contribute like $8,500 between the state and local match for this upcoming school year. The ESA amount is, and I'm going to give a little bit of background here because the numbers do get a little confusing, but the statewide average is $8,684, which is more than $8,500. And under the ESA Act, ESAs are supposed to be funded at the lower of either the state and local BEP allocation for the school district or the statewide average, whichever is lower. And according to our math, the statewide average is $8,684. Shelby County's BEP allocation is $8,500. So I'm not even convinced they've got the number right for Shelby. I think they're taking too much money from Shelby County. And so I think that is a direct harm, certainly, if they're not even calculating it correctly.
And you also, in the math, in your brief, talk about the 6%. And it appears that Metro and Shelby County believe that the 6% is going to be in addition to the allocation. And looking at the statute, it says the department, the state, may deduct 6% from the annual ESA award amount to cover the cost of overseeing the funds and administering the program. So how is the 6% supposed to work? Because it looks like the county plaintiffs believe that is going to be an additional 6% charge to them. I may be reading the statute wrong, but it looked to me like that was going to be an administrative fee that was going to come out of that number. And you may not know, but I was trying to figure out your math.
I thought it was an administrative fee that the state would bear too. But according to the comptroller's legislative brief that outlines how the act is going to operate, they've decided to do that contrary to the statute as well. So this is, it's Exhibit 14 to the declaration that I filed in conjunction with our motion for temporary injunction. And it's legislative brief about the Education Savings Account Act that was issued back in 2020 in advance of the initial rollout.
Thank you for drawing my attention to that. I missed that detail in that exhibit.
So on let's see, it's on page 4, if I'm remembering right. Yeah, it's on page 4. If you take a look at page 4 of that exhibit, though, it describes, it certainly suggests to us that administrative fee is actually coming off of what is taken from the LEA. So basically, and it actually works a little differently. So practically speaking, here's how this works. Every year, the districts receive a big check from the state. And that check, when in a county where the ESA Act applies, so in Davidson County, when the state sends Metro schools or Shelby County schools their BEP check for this year. They are going to take off the top the amount of money that is necessary to fund the program. And that amount under the statute is equal to the state and local BEP contribution or the statewide average, whichever is lower. And according to this comptroller brief, it suggests that the administrative fee is a 6% fee that is on top of that amount, as opposed to is coming off of that amount after it's withdrawn. That's certainly how we read it. And so the ESA that is going to the students is having that 6% taken out of it before it is deposited into the ESA. So I guess one could argue, because that dollar amount that is coming off is really a combination of state and local money, because it's money that they would otherwise be getting from the state. One could argue that it is being distributed between the two entities, but I don't think that changes the fact that the money is coming off before it goes into the student's account. And that's what this exhibit shows you. And because of that, when we take the $8,192 amount that the TDOE is saying is what students will get in their actual accounts for this year, according to that comptroller brief, we believe that 6% has to be added to that number to actually give us the number that is coming off of the LEA's checks at the beginning of the school year or at the outset of the program.
So
I know that's a lot. So
I'm confused. So who does, based on your reading, who's paying that 6%? Is it the state, the LEA, or a combination? Or is that actually being deducted from the amount that the student's getting to fund their education?
I think it is probably both of the last two things you said. I think it is fairly considered a combination of the state and city, because again, it's coming off of the check that would otherwise be given to the district. And so I think one could argue that it is a combination of state and local money, because what happens is the state takes the money off the top, and then the local government, the county, has to pay the school district its local contribution. So, but that local contribution has effectively been taken by the state when it takes that money off the top. And so if that 6% is coming off after that initial reduction, then I think it is fair to say that it is distributed between the state and the county in the same proportion that the BEP dollars are distributed between the state and the county. So for MMPS, that would be overwhelmingly more county dollars than state dollars. For Shelby, it would kind of be in the opposite direction. And then, so yeah, I think the student's account would arguably be funded at an amount lower than the statute actually says it should be funded at.
But the origin of the money is from the combination of the funding. Okay.
Yes, that's how we read it. So, and just to be clear, at some point, Greater Praise suggested, I think this was in the Mcewen briefing, Greater Praise suggested, well, this whole section that says, so back up. The government, the TDOE cannot get in place the infrastructure to be able to have actual physical bank accounts as are contemplated by the statute. They can't do that in the time frame that they want to turn this around and get it up and running. And so what they have proposed instead is that the private schools cover the tuition on the front end and then seek reimbursement from the state for that tuition. They're not asking the ESA participating students to pay anything. They don't want to shift that to them, understandably, but they want the private schools to pay it on the front end and then submit a reimbursement request to the state. Now, Greater Praise made a point in the reply brief that, well, in the section of the FAQs on the ESA's website that actually talks about this change, that's in a section titled account holder responsibilities. And I presume they're attempting to suggest that that's not actually how it's going to work. But the website itself makes this also very clear that that's what's going to be happening for this school year. On the very front page of the website, under how the program works, it says plain as day, in year one, ESA funds will be distributed directly to participating schools, reimbursing schools for student expenses. So again, this thing is moving in such a rushed, haphazard fashion that TDOE is not even complying with its own statutory requirements for how it is going to affect the program. So let's shift gears and talk a bit about the grant program. There's been discussion certainly in the briefing about, well, what about the grant program? Does that eliminate the harm to the plaintiffs? And the answer to that is no, for a variety of reasons. The grant program—
You're talking about the school improvement fund?
Yes, yes. So the school improvement fund, which operates effectively like a grant program. Just this, let's see, it would have been August 1st. So the days are running together, but I think August 1st was Monday. The LEAs received letters from TDOE, and we supplemented with those letters. And those letters indicate, again, that this is going to operate like a grant program, which means the LEAs have to apply for the funds. That's not something that automatically gets sent to them. The letters provide no information about how quickly those grant funds are going to come in. But we know they have to apply for them like they would with any other grant. We also know from the statute itself that the grant funds are only available for 3 years. So in year 4, the LEAs get no reimbursement for this loss of funding, unless, of course, it comes from the plaintiff counties. We also know from the statute, and this is not disputed, that it does not replace dollars for any student that is entering kindergarten or that moves into the district. You have to have attended an MMPS or SCS or ASD school for an entire full year before the LEA would be eligible for funds representing your ESA. Now, the district doesn't normally get funding for students who are just entering the district, because of course it may not even know about those students until they show up. But what matters here is that the district normally also wouldn't lose funding for those students. So yes, it's not taking funding that it thought it was entitled to, but it is certainly, this act certainly is taking funding that they otherwise would be entitled to keep, because those students would be entering their schools. Now, the other point to be made about the grant program is that it is subject to appropriation. So the state has appropriated money for it, but there is no mandatory requirement in the statute that be done every year. And let's talk a bit about the appropriation. The amount that has been appropriated for this act, and this is since day one, is $29 million. $29 million barely would cover 3,000 students participating in the program. The $29 million, $2 million of that is for payroll costs, according to the governor's budget. And then, so that leaves $27 million. That $27 million would barely cover 3,000 students' participation. And it begs the question, where's the state going to get the money to actually pay for contracting costs? I presume there's some administrative cost to operating this program aside from just payroll. And they haven't accounted for that at all in this appropriation either. So the bottom line is we don't know how many students are going to participate. And to the extent that it's in the $2,000, $3,000 range, I think it raises serious questions about whether the appropriation that has been granted would even be sufficient to cover all of this.
So you're saying the $29 million is the total appropriation for this year's budget for the program, not $29 million specifically for the grant program or school improvement fund, whatever you call it. That's just the bucket of money there to fund the program. And we know $2 million of that already goes to payroll at the state level to administer the fund.
Precisely. We don't see any other appropriation anywhere in the governor's budget book for this year or in the actual legislative appropriations bill, both of which we have filed as exhibits to our filings. And again, that $2 million just says for payroll. So that sounds to me like the folks who are actually running this program at the state level, it doesn't account for contracting costs that are obviously going to have to be incurred to administer a program of this size. If, of course, they actually set up education savings accounts as contemplated by the statute. So that then brings us to harm to the state. The irreparable harm, any irreparable harm that is likely to ensue here is largely one of the state's own creation. Nothing required the state defendants to push this program forward at a rocket's pace after the injunction was lifted, just before the school year started. They affirmatively made that decision on their own. They could take time to plan, update the materials, provide important information, not just to the students and families participating and the private schools participating, but to the plaintiffs who are actually funding this program, to the school districts who are going to bear presumably some administrative cost. They are the ones who have these students on their rolls. They're going to have to do something, and they've been given no information about how that is supposed to operate. So the state rushing this out the door without preparing for it sufficiently on the front end is what is likely to cause harm to the state here.
Now, the interveners are going to argue, and they have submitted affidavits from their parent clients, and I'm sure we'll hear more about it, but they have submitted detailed affidavits regarding why they think school choice is important for them and why it is an urgent matter for them. And we all appreciate the fact that you're only in first grade once or second grade once or what have you, and that every year that passes is a lost education opportunity. So how would you respond to their arguments about harm to them?
Sure. Well, the problem with those affidavits that you're talking about is they're stale. They refiled them for whatever reason, but those declarations contain no updated information. It's the same declarations they filed 2 years ago. Those students aren't even presumably in the same grade anymore. There's no evidence in this injunction record of any claimed harm by the intervener defendants. They just simply didn't respond. Their attorneys made some arguments in briefing, but the declarations that are before the court are stale. We don't know if those kids go to those schools anymore. We don't know if they want a voucher. We don't know if if a private school would accept them if they applied. We don't know where they plan on applying because, again, all of that information is 2 years old. The only evidence that we have in this record is attorneys' arguments that the intervener parents would rather their children use public funds to go to private school than attend public schools. That does not establish harm. I understand that the attorneys in this case feel strongly about their client's ability to access a school reform option, but unfortunately, their clients haven't established harm in any respect, at least not on this injunction record. And then that takes us to the public interest. And the public interest here also weighs in favor of an injunction. Withholding millions of dollars in education funding from school districts' anticipated quarterly fund payments will impose significant havoc on MMPS and SCF. Again, they are the ones that are going to have to pivot. They don't know how it's going to affect them administratively. They don't know how many students are going to participate. They don't know how much money they're going to lose. And expecting the plaintiff counties just to come in and fix all of that just shifts the harm to plaintiff counties. It doesn't solve the problem. The public interest is also not served by the state government rushing implementation of a program, particularly in a manner that is ultra vires, that involves direct payments to private schools in violation of the statutory mandate to create ESAs, actual accounts for participating students. In fact, if you take a look at the statute, the reason they wanted it to operate that way is because they want to be able to have fraud protections in place. They want this to be handled in a way that is defensible and legally sound. And instead of actually taking the time to develop all of those processes, they're rolling this out just because they want to from a policy perspective and completely ignoring those statutory mandates. So that brings us to likelihood of success on the merits. And I first want to address the two justiciability arguments that the state has raised, and I believe Greater Praise interveners also raised one of them. The first one is ripeness. Despite pressing forward with this program mid-school year, collecting intent to enroll forms, now posting application on the website, posting on social media to boost applications, and traveling across the state to encourage private schools to participate in the program, The state defendants are now again maintaining their long-held position that there is no live controversy for the court to resolve. And this just simply makes no sense. As soon as one ESA is issued, and they are doing everything in their power to make that happen as quickly as possible, as soon as one ESA is issued, plaintiff's money will have been taken to fund private school tuition in only 2 Tennessee counties. That is the injury that will have ensued. The state's rightness argument also fails to recognize that rightness doesn't even require present injury under the Colonial Pipeline decision. It only requires a present controversy. And this is unquestionably a controversy. The question of how much money will be lost is a matter of degree of injury, not presence of injury. And this program, by design, injures the counties by forcing them to fund private school tuition, unlike the other 93 counties in Tennessee. For that same reason, the standing argument fails as well. Standing requires a distinct and palpable injury, which is present here, again, as soon as one ESA is issued. Now, given the state defendants' insistence on mid-year implementation, they effectively concede that that is going to happen as quickly as possible. As of this morning, the application is live on the website, ready to go, ready to receive students, and ready to take plaintiff county money. The ESA Act defines eligibility by the school district. I'm going to shift to the equal protection claim, which is the claim that we have discussed in our likelihood of success argument. We also make an education clause claim in our complaint, but we're going to focus on the equal protection claim for purposes of the motion for injunction. So the Act defines eligibility by the school district to which a student is zoned. And this effectively creates 2 sets of classifications under the Equal Protection Clause. The first is the LEAs and students, those who are zoned to LEAs and MMPS and Shelby County Schools, and the ASD who can participate in the program, and everybody else across the state of Tennessee who cannot participate in the program. And then it also distinguishes between the counties, Davidson and Shelby County, who are mandated to fund ESA accounts by virtue of the counting requirement in the ESA Act, and the other 93 counties who are not required to fund private school tuition in the state of Tennessee because they are protected from the Act. Now, I want to address an argument that has creeped into some of these responses to the motion for injunction. And it's an argument that just misunderstands equal protection law. The defendants argue that a statute is not subject to equal protection scrutiny unless on its face it regulates the plaintiff county's conduct. And of course, the reason for this argument is obvious. They're trying to latch on to some language from the Supreme Court decision specific to the Home Rule Amendment claim and claim that it bars the equal protection claim here. But it's just a totally irrelevant argument. Equal protection protects unjustified classifications against unjustified burdens, and the groups of people that the bill treats differently do not have to be explicitly identified on the face of the bill. The question is, does it create classification? Does it impact a suspect class? If the answer to those questions is yes, then it invokes equal protection scrutiny. And depending upon whether the right is fundamental that it impairs, or if that classification is a suspect class, such as race or gender, then it's subject to strict scrutiny. The Rodriguez case that is cited in our brief, it's a U.S. Supreme Court case that examined a school funding formula in the state of Texas, actually refutes directly what the defendants are claiming here. In that case, the court spends the entire first section of the opinion examining who the act had an impact. Well, who was burdened by the act effectively? Because in this particular situation, it was similar to many funding challenges. There was concern about whether individuals in poverty whether their schools were being funded sufficiently. And in that case, the court went through great lengths to talk about the various classifications or the various burdens that it could create on the various types of classes. And the court never would do that. The court never would have done that if those classifications or those burdens, those groups, so to speak, had to be identified on the face of the bill. And we quote language directly in our reply brief where the Rodriguez case establishes that that's just not how you look at it. The question is, does the impact of this bill create such a classification? Does the impact of this bill create such a burden on a suspect class? And in this instance, it does. In this instance, counties aren't directly addressed on the face of the bill. They don't have to be, because everybody knows that under general school funding law, counties pay for school districts. Instead, they just implement this counting requirement on the school districts that effectively forces the counties to keep paying for these students, even though they have left the public school system altogether. The Equal Protection Clause also protects individuals and counties. And this is crystal clear in the Civil Service Merit Board of Knoxville versus Burson case, which is a 1991 Tennessee Supreme Court decision. There was sort of a quick comment in the intervener defendant's response about that shouldn't be the case. You know, basically, we don't think counties should have an equal protection right, but respectfully, that's just not something they get to decide. The Supreme Court has said that counties do have an equal protection right in that Burson decision. So the question then becomes, what level of scrutiny is this act subject to? And it's our position that the act is subject to strict scrutiny. For purposes of the Tennessee Constitution, a right is fundamental, and this language is key. This language is key to our argument. A right is fundamental when it is, quote, either implicitly or explicitly protected by a constitutional provision, end quote. And that's from the State v. Tester decision, which is an equal protection case that is cited in our filings. And it's also a concept that comes out of the small schools case, which is also an equal protection decision out of the Tennessee Supreme Court. That concept of protecting rights that are explicitly or implicitly protected in the Constitution also works the same way in the US Constitution. And the Rodriguez decision is a perfect illustration of that. In Rodriguez, the Supreme Court of the United States said there is no fundamental right to an education under the 14th Amendment to the US Constitution. And that's because the US Constitution doesn't say a word about education, because education is generally a right that has always flowed to the states and to the local governments, typically through funding formulas. But the opposite is true here. The opposite is true under the Tennessee Constitution. And in fact, there are two constitutional provisions that establish a fundamental right in this case. First, the home rule provisions, which are lengthy and provide myriad protections for local governments against infringements on their local sovereignty. And then also the Education Clause itself. At its core, the Education Clause is about, it's not about providing an education. It's not about the state providing an education. States generally don't do that. It's about funding an education. And small schools makes that very clear. There is a constitutional requirement to fund schools at a level that is adequate. And the ESA Act fundamentally impairs two LEA's ability to provide an education by taking millions of dollars from them. And again, even after 3 years, that money is not going to be replaced at all. And again, who is responsible for funding those LEAs? The plaintiff counties are Shelby County and Davidson County. Funding is a zero-sum game. Taking millions of dollars from those LEAs to send to private schools and expecting the counties to foot the bill in only 2 counties impairs that fundamental right. But that is not all. The Tennessee Supreme Court has already acknowledged in this very case that counties have a, quote, constitutionally protected interest in local control of local affairs, end quote. And it ruled this when it held that the plaintiff counties had standing to assert a home rule amendment claim. Now, and then what did Tester tell us, the case that I just spoke about? Well, it tells us that a right is fundamental for equal protection purposes when it is, quote, either implicitly or explicitly protected by a constitutional provision. In other words, the right to local control of local affairs, just as the Supreme Court said, is a constitutionally protected right. In fact, it is explicitly protected, and the Supreme Court acknowledged that it is infringed in this case. The fact that plaintiff counties home rule amendment claim failed on a technicality of what applicable to means. Was it applicable to the counties because it didn't address the counties by name? Instead, it just triggered existing legal requirements. That technicality does not render that constitutionally protected interest not a constitutionally protected interest. It's still a constitutionally protected interest by the Tennessee Supreme Court's own words. And because of that, because it is explicitly protected, and because the Tennessee Supreme Court has already held that this act infringes upon it, then this court necessarily must hold that it is a fundamental right. So then how does the act fare under strict scrutiny? And the answer here is not well, but the court doesn't even really have to answer that question because defendants just haven't even responded to the argument. There is not a single argument in any of the response briefs as to how this act would be narrowly tailored to a compelling state interest. And we would submit, of course, because they couldn't satisfy that standard. That standard shifts the burden to justify the classifications to the state itself. It requires a compelling state interest, and it requires that the means for accomplishing the purpose of the act be narrowly tailored to that compelling state interest. If there are alternative means for achieving that goal, it is not narrowly tailored. Now, in this case, we don't even have to speculate about what the quote unquote government interest was because the legislature spelled it out for us in the bill. It says in Tennessee Code Annotated 49-6-2611 that the General Assembly recognizes the state's quote legitimate interest in the continual improvement of all LEAs, and particularly the LEAs that have consistently had the lowest performing schools on a historical basis. And then they go on to say, accordingly, we're going to create this pilot program. The state has a legitimate interest, according to the General Assembly, in improving the performance of Davidson and Shelby County schools, because that's who they're talking about, right? Because that's who it's the only counties the bill applied to. The state has a legitimate interest in improving the performance of those schools. So the solution to that is to take thousands of their students out of those schools and millions of their dollars and send them to private school. That's the proposed solution for improving schools in Nashville and Shelby County. Meanwhile, the state breaks even. It doesn't lose a single dollar more than it would lose if those students stayed in public school. They just take the money that they otherwise would have given. Not a bad deal for the state, but certainly not narrowly tailored to the General Assembly's stated interest of improving school performance in Nashville and Davidson County and Shelby County. If it were tailored to that interest, then the legislators would have been begging for access to this program, right? Because they would want to improve their own schools. They would be begging for access to education savings accounts. And we all know that they were not. They were cutting deals on the House floor so their own districts would be, quote, held harmless from the bill. Those were Representative Zachary's words. Representative Zachary in Knoxville. We want to be held harmless. I am willing to give you my vote because you are agreeing to hold my county harmless. How can you argue on one hand that this is intended to benefit the school districts to which it applies, while at the same time exchanging votes so your own district wouldn't be harmed by its purported benefit? The stated interest in this bill is pure fiction, and taking millions of dollars away from public schools and sending it to private schools will never help those public schools. That is not narrowly tailored. It is completely illogical. So instead, let's assume the General Assembly had another reason for this bill that they didn't explicitly articulate. But we know the goal wasn't to help students in low-performing schools because this bill permits any income qualifying student in any school in Davidson County to attend private school, even if that student attends Hume Fogg, one of the top 100 high schools in the country consistently year after year after year. And even if the legislature's interest was helping students in low-performing districts, they still haven't treated similarly situated groups similarly. In 2017, Fayette County had a higher concentration of bottom 10% schools than Davidson County. Madison County in Jackson had a higher concentration of bottom 10% schools than Davidson County and Shelby County. In 2018, just before the act was passed, Fayette County and Madison County had a higher concentration of priority schools than Davidson County and Shelby County. Hamilton's was just a couple percentage points lower, and Hamilton and Fayette County had a significant downgrade from their priority school numbers from 2015. If the goal were to help students in low-performing districts, the legislature would have helped students in low-performing districts. It would have provided ESAs to students in Madison County or Fayette County. Fayette County, where nearly 35% of their district schools were in the bottom 10% of the state in 2017, 10 percentage points more than in Nashville. Instead, this program encourages students to leave public school, thousands of them taking millions of dollars with them. Helping students in low-performing districts wasn't the goal. The goal was to pass a voucher bill, any bill at any cost that could make it through the legislature, even if that meant treating LEAs in Shelby County and Davidson County differently than similarly situated districts. Singling out the LEAs in those counties was the only way they could get this bill across the finish line. And equal protection required the General Assembly to narrowly tailor the bill, and this bill does not come close. As the evidence we have presented shows, the ESA Act treats similarly situated LEAs differently, and the counties that are required to fund them are necessarily the ones that are injured, to the detriment of those LEAs, to the detriment of the students in them, and certainly to us, the plaintiff counties, while 93 other counties are protected from those harmful effects. The likelihood of success prong also weighs in favor of an injunction. So I'm going to wrap up. The state defendants are rushing to implement the ESA Act in a manner that is sure to create chaos. It is creating chaos day by day by day as we see new information being rolled out onto the website, even claims of being able to operate in a manner contrary to the statutory mandate itself. We ask the court to enjoin the state from awarding any ESAs or using any public funds to support this program until the court can set an expedited schedule and decide this case on the merits. Maintaining the status quo is the only way to prevent irreparable harm in this case. Thank you so much.
Thank you so much, Ms. Bussell. With no further questions to you at this time, we'll turn to Mr. Wood, the lawyer for the Mcewen or parent plaintiffs in the 242 case.
Good morning, Your Honors. Christopher Wood on behalf of the Mcewen plaintiffs. Your Honors are familiar with the legal standards, and I'd like to jump right into the likelihood of success on our motion. Your Honors, we are likely to succeed on our claim that the voucher law violates the Education Clause's mandate for a single system of public schools. To understand just how fundamentally unconstitutional the voucher law is, I think it's worth stepping back and thinking about the big picture of what defendants are claiming through both the voucher law itself and the claims that have been made in this litigation. What has been claimed essentially, as you mentioned, Chancellor Martin earlier today, is that students are trapped in failing schools in Nashville and Shelby County, and that vouchers will allow students to get out of these so-called failing schools and attend private schools, which will provide a better education. And I think it's important to state at the outset, and this is discussed at pages 18 through 22 of our opening brief, that the notion that we can fix so-called failing public schools by sending kids to private schools is fundamentally incompatible with the state's obligations under the Education Clause as they've been interpreted in small schools. The Constitution requires that the state provide an equality of educational opportunities through a system of free public schools. That is the explicit holding of small schools. Defendants here essentially say, we are failing to provide an equality of educational opportunities through a system of free public schools. So let's have those kids abandon the system, defund that system, and turn to private schools instead. That is not what the Constitution requires. It requires the equality of educational opportunities to be provided through a system of free public schools, period. And because the voucher law necessarily frustrates and is incompatible with that mandate, it is unconstitutional. Now, focusing on the specific language of the Education Clause, as we know, it states in its entirety, the state of Tennessee recognizes the inherent value of education and encourages its support. The General Assembly shall provide for the maintenance, support, and eligibility standards of a system of free public schools. The General Assembly may establish and support such post-secondary educational institutions, including public institutions of higher learning, as it determines. And of course, what we've asserted in our brief is that this language, read collectively, shows that the state cannot fund private K-12 education. It can fund private post-secondary education. It cannot fund private K-12 education. Defendants, for their part, essentially contend that the second sentence is just a baseline and the state can go beyond that if it wants, including to fund private K-12 schools. The problem with defendants' argument is that the second sentence is just a baseline in terms of funding, then the third sentence of the paragraph about post-secondary education is completely superfluous. Why do you need to say that the General Assembly may establish and support post-secondary educational institutions if there is no limit on how the state funds education in the first place? Defendants' reading would render that final sentence superfluous, meaning in essence that a third of the entire Education Clause is superfluous. And the Tennessee Supreme Court has endorsed the common principle of interpretation that we must construe a statute so that no part will be inoperative, superfluous, void, or insignificant. This reading is also supported by the principle of expressio unius, as we talked about in our brief, that the expression of one thing implies the exclusion of others. In Southern versus Beeler, Tennessee Supreme Court case from 1946, which we cite on page 22 of our opening brief, demonstrates that the Tennessee Supreme Court has applied this principle specifically with respect to school funding. And so on the face of the text alone, the court can find that the Education Clause makes the funding of K-12 private schools unconstitutional. But if it were at all ambiguous, Your Honors, you could go further and do what the Supreme Court did in small schools and look at the record of the 1977 convention related to the Education Clause for guidance. And as we say in our reply, there was vigorous discussion about amending the final sentence of the Education Clause to add the word public. In other words, the General Assembly may establish and support such public education institutions. And there was an express recognition that inserting the word public in that sentence would necessarily mean that private post-secondary institutions were excluded. And that is incredibly probative regarding the understanding of that language, the understanding that public necessarily excludes private. Moreover, as we point out in our reply, it's not as if the legislator wouldn't have been aware that K-12 private schools existed. Private schools were being used throughout the South after Brown v. Board in an attempt to avoid integrating schools. You don't even have to read any of the sources that we provided the defendants objected to see that. Coffey versus State Education from Mississippi, which we cited in note 6 in our reply, lays it all out. Yet the express purpose of amending the Education Clause was to remove the provisions mandating segregation, and Delegate Helms, the chair of the Education Committee, said that the committee was trying to avoid any controversial items that could endanger ratification of our proposal. And it would be strange indeed if they had intended to leave the door open to private K-12 school funding, when, as Coffey makes clear, that practice was hugely controversial and those programs were being unanimously struck down as unconstitutional across the country. And so, Your Honors, I would respectfully submit we have demonstrated a substantial likelihood that the voucher law is unconstitutional because it violates the Education Clause. I want to talk a little bit about the harm, and I think that Ms. Bussell covered a number of the harms that are going to be caused if the voucher law is allowed to be implemented. As to harm, my clients suffer 3 types of harm from the state's attempt to rush the implementation of the voucher law. First, the loss of a constitutional right, even for a minimal period of time, is unquestionably constitutes irreparable injury. Diverting funds from public schools in Nashville and Shelby counties, and only Nashville and Shelby counties, where my client's children attend school, will have an adverse impact that violates the state's obligation to provide substantially equal educational opportunities through a system of free public schools. And where, as here, a constitutional right is being threatened or impaired, a finding of irreparable injury is mandated. My clients also suffer harm as taxpayers when funds are unlawfully diverted from public schools to private schools. There is no way to recover those funds. There is also harm from the disarray and dysfunction that the state has caused and is continuing to cause by attempting to rush out vouchers just days before the beginning of the school year. Recall that in Critz versus Smith from the Tennessee Court of Appeals, which is cited on page 20 and 21 of our opening brief, the Court of Appeals upheld an August 1st deadline for a parent to tell a district that a child will be homeschooled and not attend public school. The court found that without providing such notice, a student would be expected to attend a school, and quote, their absence will affect adversely the operation of the school system for the year. What we have here is even worse. Without an injunction, the state could award vouchers at any time, this weekend perhaps, or in the middle of the semester. All of us who have children in school know how disruptive this could be for students and schools. Your Honors, I'm literally leaving my office this afternoon after this hearing to go to an open house at my child's school. And for my clients and for those of us that have done similar things, you can see the efforts that schools put in to prepare for the semester. Class rosters are posted. Students may have their names on desks. Families are meeting with teachers and getting to know each other. A haphazard implementation like the state's advocating injects chaos into that process. Schools, students and families uncertain about where their children will go to school. Schools having to plan right now for the fact that they may lose students mid-semester. All of this is totally unnecessary and should be halted before even more harm occurs. As to balance, and as Ms. Bussell said, and I think she put it very well, there has been no showing of harm to the defendants. Your Honors, what we've heard from the defendants for the last 2.5 years here in Chancery Court, at the Court of Appeals, at the Supreme Court, and I'm sure we'll hear it again today, is that parents need vouchers because public schools are inadequate, and that the state is apparently not fulfilling its obligations under small schools. And while there's been a lot of ink spilled about kids in so-called failing schools, there's nothing that connects that purported harm to a lack of vouchers, and no showing whatsoever that allowing vouchers to proceed will remedy that harm. Both Nashville and Shelby County have robust public school choice options already. If folks are unhappy with their schools, they can opt to go to many different other public schools. Some of the school choices available in Nashville and Shelby County are some of the best ranked schools in the entire country, like Hume Fogg, where I happen to go to high school and is right down the street. Not only are there robust public school choices, but there is no evidence whatsoever that any of the intervener parents will be awarded a voucher, that their child will be accepted into a voucher school, or that even if they are accepted, that a voucher school will provide a better education than that which is available at a public school. There is no evidence in the record whatsoever. And so I would submit, Your Honors, that as a matter of law, there is no opposing harm to balance here. Your Honors, we obviously agree that we need to invest more in public schools. I agree that we have schools throughout the state that, despite their best efforts, are struggling with inadequate resources, and schools that are having to overcome the challenges associated with educating students who are suffering the impacts of intergenerational poverty and discrimination. Schools that, despite the costs, have an obligation to welcome and educate everyone who walks in the door, even if that person happens to have a disability, and even if that person happens to be a refugee who's never had the opportunity to attend a school before in their life, as many of our schools in Nashville and Shelby County proudly do. But Your Honors, the solution to those challenges cannot be to cause still further harm by defunding public schools and sending desperately needed tax dollars to unaccountable, potentially discriminatory private schools. As Small Schools says, the Constitution does not permit the indifference or inability of state agencies to defeat the constitutional mandate of substantial equality of opportunity. The Constitution demands adequate and equal public schools, not throwing our hands up and saying, let's move kids to private school and further defund public schools. That's going to exacerbate the challenges that we are already facing and cause further harm. It's not an answer to any inadequacy within the public school system. And so on the issue of harm, Your Honors, I would respectfully submit that the only harm that could occur is for vouchers to be allowed to proceed, and that this factor weighs strongly in favor of granting the injunction. With respect to the public interest, some of those have already been addressed, but the public interest clearly favors an injunction. There is a public interest in preventing the implementation of an unconstitutional statute. There is a public interest in not wasting public funds on an unconstitutional statute. There is a public interest in preserving the status quo and allowing these issues to be fully resolved by the courts. Even if the voucher law was ultimately found to be constitutional, which we submit it will not be, there is a public interest in an orderly rollout of the program, not violating the statute from the outset by directly reimbursing private schools as the state has apparently proposed, not potentially shuffling students in and out of school mid-semester. Some of the defendants have stated that they want the program implemented now and that they're willing to live with these potential disruptions. But these decisions don't just impact them. They impact other students, whole classrooms, schools, and school districts. The public interest strongly supports an injunction. Your Honor, there's also discussion in the opposition briefs of the Mcewen plaintiffs' standing. I think it's clear that the Mcewen plaintiffs have standing to bring all their claims, including the claim that we're proceeding on for purposes of the temporary injunction. The Mcewen plaintiffs are taxpayers challenging illegal government action that unlawfully diverts public funds. The only real challenge defendants make to standing here is that we haven't pled that demand is excused or that a demand would be futile, as if there's some magic words that must be pled in a complaint to invoke demand futility. This is not the law. And what we have pled and what the court can take judicial notice of from the proceedings here and at the Court of Appeals and the Supreme Court is that a demand that the government halt the voucher law would be completely futile. After everything that we've been through in the last few years, all the challenges, the state is still trying to implement the voucher law even this morning as we speak. To suggest that a demand would not have been futile is patently absurd. Second, plaintiffs can show standing because they allege a special injury, status, or relation that isn't common to the body of citizens as a whole. Only students and families in Nashville and Shelby County.
I'm sorry. This is the court reporter. You were getting drowned out on your last point with some papers shuffling. Can you?
I think that's, Madam Court Reporter, I think that's my fault. This is Chancellor Martin. I'm going to mute my microphone while Mr. Wood is talking, and I'll just unmute it if I'm speaking.
Thank you. Sorry.
Thank you.
So by the second point on standing, plaintiffs can also show standing because they allege a special injury, status, or relation that is not common to the body of citizens as a whole. Only students and families in Nashville and Shelby counties are burdened by the voucher law and the funds it will take away from their schools, not citizens in the rest of the state. And as such, they are uniquely harmed by the voucher law and have standing to sue in that capacity. The Curve case on page 6 of our reply, I would submit, strongly supports this proposition. And so, Your Honor, for all of those reasons, we would respectfully ask that the court issue the requested injunction and enjoin implementation of the voucher law in its entirety at this time. Thank you very much.
Thank you so much, Mr. Wood. We'll turn now to Ms. Bergmeyer on behalf of the state to address both motions, all of the issues that were raised in no particular order, whatever suits you. Ms. Bergmeyer, however you've organized your argument.
Thank you, Your Honor. I will be addressing the Metro Government and Shelby County plaintiffs motion, and then Jim Newsome will respond to the Mcewen plaintiffs motion if it pleases the court. Good afternoon, Your Honors. The plaintiff county's motion for temporary injunction should be denied. There are families and students who have sought the benefit of the ESA pilot program for over 2 years and have been unable to enroll. For these low-income families who have students zoned to attend schools in the poorest performing LEAs, every year of their child's education is meaningful. Having delayed the ESA program for over 2 years and putting their best argument before the Supreme Court, the county plaintiffs lost that argument. And they are now back before this court seeking an extraordinary remedy on temporary injunction and a more tenuous claim. A temporary injunction is only authorized under Tennessee Rule of Civil Procedure 6504 if it is clearly shown by a verified complaint, affidavit, or other evidence that there is a violation of that party's rights and irreparable injury. Tennessee Supreme Court has stated that there is no power more dangerous in a doubtful case than the granting of an injunction. The county plaintiffs failed to show the probability that they will succeed on the merits of their equal protection claims. This is an determinative factor and warrants denial of their motion. In addition, the other factors do not support the granting of a temporary injunction and also support that the motion should be denied. First, going to the fact that the plaintiff counties are unlikely to be successful on their equal protection claim. It is important that the court must presume a statute is constitutional and resolve every doubt in favor of the statute. The plaintiff's arguments are contrary to this principle. Their argument is replete with assumptions and speculations as to how the ESA pilot program could conceivably harm them. It is important for this court to carefully review those arguments and ensure that it stays aligned with the presumption of constitutionality that it must follow. For instance, I would like to address the argument that the plaintiff counties have raised that the department will add 6% to the ESA amount as administrative fees. As you noted, Chancellor Martin, the language of the statute, which is found in Tennessee Code Annotated 49-6, 2605, subsection 8, states that the department may deduct 6% from the annual ESA award amount to cover the cost of overseeing the funds and administering the program. Once again, the statutory language says that the department may deduct 6% from an annual ESA award. Plaintiffs construing this provision to add 6% to the ESA award is contrary to the plain language of the statute. And in addition, counsel this morning pointed your honors to the comptroller's brief, which they filed in support of their motion. It's Exhibit 14, and specifically pointed your honors to page 4. And I would like to address that this comptroller's report does not support that number one, let me say that this comptroller's report does not establish how the Department of Education will implement the program. But nevertheless, turning to page 4, it also does not establish that 6% would be added to the ESA award. In fact, it supports the opposite conclusion. So turning to page 4, in the second paragraph, it begins that students with ESAs will receive their proportionate share of the district, state, and local DEP funding. It then goes on to state, and I'm going to read the last sentence for your honors. Because Metro Nashville and Shelby County both generate more BEP funding per student than average, next year's ESA students will receive the lower statewide amount of $7,572 each. And I'm going to stop reading there. Then, if you look to the next paragraph, it says that the state law also allows the Tennessee Department of Education to hold back 6% of the amount given to students as an administrative fee. This fee will help cover the department's cost of running the program and works out to about $454 per student. After the fee is deducted, each student will receive roughly $7,117 to put towards a private school tuition or related expenses. Now, if your honors take the time to do the math, if you look to the $7,117 and add the $454 per student fee, you get the ESA amount that the comptroller puts forth in the preceding paragraph of $7,572. So they say that the ESA amount of $7,572, subtracting the 6% administrative fee, not adding it, will then put $7,117, that's the remaining funds, into the student's account. So in fact, page 4 of the comptroller's report verifies that that 6% will be deducted from the ESA amount, not added to it. This shows one of the problems that is put before the court today, given the timing of the temporary injunction motion and the fact that plaintiffs are arguing their interpretation of statutes and other reports that is in fact not correct, and is contrary to this court's obligation to construe a statute in support of the constitutionality.
Can I interrupt you for a minute, Ms. Bergmeyer? Don't you think that if the state had conducted proper rulemaking as the statute contemplates at 2603D, that a lot, or 2603L, I'm sorry, that a lot of this would be avoided? I mean, we've talked today about several things that the county plaintiffs assume and the parent plaintiffs assume, and I know you're going to address some of that because you've been taking notes and are anxious to address those. And for instance, the 6%, if the state was doing this in a thoughtful, measured manner and engaged in rulemaking, which is exactly what the statute provides that it would do and should do, then maybe a lot of these questions and these insecurity or these uncertainties would be answered. That is one of the frustrations that we perceive from the county plaintiffs. Now, whether or not that justifies an injunction or whether or not that shows likelihood of success in the merits, it is a very valid point that this is all inconsistent, rushed, unclear, different sources of information that are difficult to discern. And it would be the state's obligation in rolling out a program to engage in proper rulemaking. That's why the Administrative Procedures Act has the provisions for that to occur. So I would like to hear from the state about that.
Yes, Your Honor. And I also will address this later on in my argument when I go to the balance of the weight of harms. The Department of Education has always worked for a quality rollout of the ESA program. The State Board of Education supports them with rules, and they were not able to fully implement that program in 2020 because of the injunction entered in this case. So it is a harm to the state to allege that they are rushing into this program, that they could implement the program better when the state has been using its best efforts to a quality rollout and simply has not been afforded the opportunity to actually.
That doesn't answer the question of why does it have to happen in 3 weeks' time or a month's time? You know, again, it is the state's obligation to follow the statute, and there's a whole list of things that the state is not adhering to. It's not setting up accounts, rather it's doing the reimbursement to the schools. It hasn't done any rulemaking to answer all these questions. You know, I mean, the real issue is the state's obligation to do it right according to the statute as enacted by the General Assembly. And so the state is choosing to hasten the timeline, and, you know, there is no injunction that is stopping the state from doing that, but there is a right way to go about these things. And I think that's the real question, is you're pushing it back on Metro and Shelby County's interpretation of how the 6% is going to be, how it's going to be funded, but some confusion and some concern and some head scratching is fair given the state's timing on this.
Well, respectfully, Your Honor, the state is implementing the program in a quality way. For instance, the rulemaking on the 6% administrative fee is not necessary when the plain language of the statute states that the department may deduct 6% from the ESA award. I don't think that further explanation or rulemaking is necessary on something that is so plain and clear from the statutory language. The state is implementing the program in accordance with the statute. They are looking to a quality rollout. For instance, the ESA accounts, the statutes do not specify where those accounts reside, that they have to reside with a third party in a class wallet or whether they can reside with the department. And so that is not an infringement upon the statute.
No, but the statute, pardon me, but the statute specifically talks about the accounts and the student's ability to use the accounts for different things, what to do if there's excess money when they turn 22. The statute reads as if it is a bucket of money available to the students to use for the statutory purposes. And it does not, I mean, there's nothing to indicate that's what's happening.
Respectfully, Your Honor, the department is still in the implementation phase of the program. Those accounts can remain with the department. It could remain elsewhere. And there is, we're here today on a motion for temporary injunction, which requests clear evidence that there is harm to the plaintiff counties, and respectfully, how the department is choosing to responsibly roll out the program does not establish any harm to the plaintiff counties here, and there's no clear evidence that it would. And so I see this argument by the plaintiff counties as a red herring. Certainly the department is following the statutes and enrolling the program as it sees fit, but in a quality way. But it has been prevented from doing that because of this lawsuit and the plaintiff counties argument. And they're arguing their interpretation of the law, which is flatly incorrect, does not support clear evidence that they're harmed or that there's irreparable injury here.
You answered my question. Sorry, go ahead.
Thank you, Your Honor. So I would simply submit that 6% is one example about how the court cannot rely on the plaintiff's arguments that are contrary to the clear language of the law and are contrary to the presumption of constitutionality in this case. So looking at the merits of equal protection claims, strict scrutiny is not the proper standard of review. Plaintiffs have cited no case that utilizes strict scrutiny to analyze an educational program in the state of Tennessee. Small Case 1 did not establish that strict scrutiny is the correct standard of review, and no other case has as well. And in fact, if you look at whether there is a right provided in the Tennessee Constitution, as the plaintiff counties argue, the Education Clause guarantees a right to a student for a free public education. It does not guarantee the county funding for students residing within their LEA. So the right looked at in the small cases is different than the right asserted here. Strict scrutiny is reserved for a very small number of cases when there's a fundamental right or a suspect class, and it is simply not established that that is the proper analysis today. So the ESA program is properly reviewed under the rational basis standard. The Tennessee Supreme Court in Harrison versus Rader has stated that it is not a court's role to question the wisdom or lack thereof of legislation under review. Rational basis is a lenient standard, and if any fact may reasonably be conceived to justify a classification, will be upheld. There are numerous facts that justify the ESA pilot program. On the very fundamental level, operating the pilot program in the two largest school districts in the state helps to evaluate the effectiveness of the program and serves as our rational basis. These districts have shown poor performance and accountability metrics over a number of years, and they have a greater number of schools who wish to participate in the program. Looking at the legislative intent in 49-6-2611, it does specify that following the third year of implementation of the program, that the Office of the Comptroller should evaluate the efficacy of the program, including whether it is in fact benefiting students in their performance, their graduation rates, whether parents are satisfied with the program. And so it is reasonable to apply the pilot program to the two largest districts in order to accomplish the best accomplished and decide whether the program is in fact serving the purpose of affording students a better or different educational opportunity. It also limits the program to low-income families, and this ensures that those that need additional educational options for their children have that opportunity. Looking at the performance data also ensures that LEAs who have a history of poor performance, not just 1 year, but in fact 3 separate years, that students within those LEAs have the additional educational opportunity of the ESA program. There is a rational basis. There is a way that this court can conceive that the statute meets the purposes that the legislature is sought to accomplish.
I'm sorry, there's some interference in the background and you just cut out.
Thank you, Your Honor. There are a number of ways for which the facts can be perceived and can be raised that support that the ESA program and its statutes are reasonably related to the legislative purposes of affording educational opportunities to students who families have a low income and are zoned to attend the poorest performing LEAs in the state. So certainly with the presumption of constitutionality and that any conceivable fact can support a rational basis, that is clearly met here. The plaintiffs are unlikely to succeed in their equal protection argument. Also, as a fundamental level, equal protection only looks to whether there's a difference in classification, and the state respectfully submits that the plaintiff counties are not being treated differently than any other counties in the state. The Supreme Court did analyze the ESA program when they looked to it and said that the ESA program does not regulate the counties, and that these funding requirements that the plaintiff counties argue cause them harm are in fact not part of the ESA program. It is due to other statutory obligations as to educational funding, such as through the DEP that puts the funding obligations on the counties, not the ESA program itself. The Supreme Court stated, like any other county in the state, they are simply obligated under other educational funding statutes to provide monies to the LEAs. The counting requirement that the plaintiff counties argue about is on the LEAs, and then the counties then fund the number requested by the county. The legislature has a considerable latitude in making a determination as to what is different and what is the same. And respectfully, under the analysis of the Supreme Court, the ESA program does not differentiate these county plaintiffs from other counties in the state. Other reasons that counties are unlikely to succeed on the merits of their equal protection claim is due to ripeness. The plaintiff's equal protection is premised on being treated differently due to funding of the ESA program. They have stated today that they will lose millions of dollars. We'll get into that argument later. But the fact is that whether the counties will lose money, whether the LEAs risk any loss of funding is not ripe until the program has been fully implemented. And in addition to the fact that the local match, the DEP funds will go to the ESA program, there is in fact a grant amount that will be equal to the ESA amount for a participating student that will be paid to the LEA. So any ESA amount that leaves an LEA will be repaid by the state of Tennessee. And in their reply, the plaintiff county submitted a letter that went from the Department of Education to the county school board that made it clear. And plaintiffs counties recently stated that the state is trying to roll out information as it is available. This is one instance where the state had information available it could provide to the county plaintiffs, and they state that the department will structure the grant allocated under the ESA program to be equal to the level of flexibility as to the student state funding. And so whether this is DEP funding that remains with the LEA or whether it's paid through this grant fund, The state has verified through a letter sent this week that not only will the LEAs receive an amount equal to the ESA amount that leaves the LEA, but that they will structure the way that the grant is allocated so that it has the same flexibility as DEP funds. This establishes that there is no financial injury to the LEA, and certainly there is no clear evidence that there is or will be a negative fiscal effect to the LEAs. Fiscal effect to the plaintiff counties and whether they'll have to budget more money is even further afield and speculative to any harm to the LEAs themselves. Plaintiff counties, to the extent they submit they will have to budget or fund more money to their LEAs, are claims that have not matured sufficiently to warrant judicial intervention and should be dismissed. Looking to the plaintiff county's standing, they do not have a distinct and palpable injury. Without going into the merits of the claims and asserting that they are being treated differently, they have failed to assert rights of their own in most of their arguments. They allege that the LEAs risk loss of funding. They assert that their LEAs or their school systems are being treated differently. For instance, today they brought up, well, Fayette County has poor performing schools, and so do these other counties. In making that argument, the plaintiff counties are not asserting rights of their own and that they as a county are being treated differently. And the Supreme Court in this case has stated it is beyond refute that the LEAs are distinct from the county government. And on page 153 of their opinion, the Supreme Court stated, this court also rejects the trial court's finding that plaintiffs are so intimately related to their respective LEAs as to render them one and the same, thus making the ESA Act applicable to plaintiffs. So because of the merits of this claim and that the ESA program needs rational basis review, because the plaintiff counties lack standing and their allegations are not ripe for review, it is unlikely that they will be successful in their equal protection claim, and this ground alone would warrant the court denying their motion for temporary injunction. I'd like to address the irreparable injury prong on whether to grant the temporary injunction motion, and there is no immediate or irreparable harm pending final judgment in this case. Once again, the plaintiffs claim harm to their school districts, not to themselves. When they discuss the counting requirement, this does not impose an immediate harm on the county. The Supreme Court analyzed the counting requirement in their opinion, and on page 152, the Supreme Court stated and agreed with the explanation of intervener defendants that the language of the ESA Act sets responsibilities on the LEAs as to how they count. The LEAs then turn those counts over to the counties, but it's not that the county is doing any different counting. This is the Supreme Court goes on further to state it is the conduct of the LEA and how it counts its students that the Act governs and regulates. The obligations of the counties to fund the LEA are derived from other statutory provisions relating to school funding outside of the ESA Act. Contrary to what the plaintiffs' counties state in their response, the state defendants have never conceded that the plaintiff counties bear the financial burden of the ESA program. And in fact, I think a claim was made today when discussing irreparable injury by the plaintiff counties that the state is not paying a penny more than it's in public school. Respectfully, that is incorrect. The state puts its share of the DEP funding into an ESA account. So that is one way that the school pays for the ESA program. In addition to that, the state has committed, there are grant funding provided under the statute, and the state has committed this year that it will match the full ESA amount and provide that to the LEAs under the School Improvement Grant Program. So the state is paying the ESA, the full ESA amount, in addition to its state contribution for the ESA program. If we look to whether the plaintiffs have put forth clear evidence of irreparable injury, the declarations that they have attached to their motion from the CFOs of the Metro Nashville and Shelby County schools do not establish irreparable harm. These affidavits do not take into account that the district will receive funding for this school year in an amount equal to any money that goes into the ESA award. So that grant program negates, is not taken into consideration, and their declarations do not establish that that the LEAs will incur financial harm. Moreover, before the Supreme Court, in their appellee brief on page 31, the plaintiffs themselves acknowledged that if the ESA pilot program is implemented, their total appropriations remain roughly the same. So they have previously admitted in this litigation that their total appropriations remain roughly the same. That is not only in their brief, but it was stated by the former Director of Law, Robert Cooper, in oral argument before the Supreme Court. Once again, it was argued today by the plaintiff counties that they think that the state will take too much money from Shelby County. That is not established by any of the declarations or evidence that has been put forth before the court. I would respectfully submit it's another example of the plaintiff counties taking an interpretation of the law that is supports their position as unconstitutional and is contrary to the duty of this court. The appropriations here that has been put forth in the record by the plaintiff counties also does not establish that there's irreparable harm here. They put forth that there are appropriations, $29 million for the ESA program, and they state that would barely cover 3,000 students. Well, this program has been under litigation since its inception, and nevertheless, the state legislature continued to appropriate $29 million to go towards the cost of the program. They also have argued, well, the state, has administrative fees that must come out of that $29 million, and so it's not certain the appropriations would cover the grant program. Once again, this is not the standard of injunctive relief. There must be clear evidence of injury, and not only is there the $29 million appropriated for the program that could cover the grant funds, but we know by statute that there's a 6% administrative fee that can be taken from an ESA amount that would help cover the administrative cost of the program. And so the appropriations amounts do not establish a clear and irreparable injury by the plaintiff county. An injunction, if we look to the balance of harms, an injunction will cause greater harm to the defendant than any harm faced by the plaintiff county. The department has worked incredibly hard since the injunction was lifted on July 13th to implement the ESA program. Anytime the state is enjoined from effectuating statutes duly enacted, it suffers a form of irreparable injury. The plaintiffs have alleged today that the ESA program is a new, undeveloped program. I don't want to repeat an argument to the court, but clearly this program is not new. It was enacted in 2009. The program tried to implement it in 2020 and got through it, partially through its implementation process, and then could not continue to implement it. Now that there is no injunction, the department looks for a quality rollout of the program, and I'll talk later about that this supports the number of students and schools that are interested in participation in the fall 2022, January 2023 school years establishes that this is a need within the state that people are looking to be able to utilize. there is a harm to allowing the plaintiffs to argue their interpretation of the law and stop the program before it's ever implemented, and then argue that it is being rolled out quickly, or that the state hasn't provided them enough information. Respectfully, the state is providing information as it is able to, and there is a harm to allowing the plaintiffs to simply create a never-ending cycle where the state is unable to implement the program, and we can really see if it affects the plaintiff county, which we respectfully submit it does not.
Can I go back and ask you a question about the $29 million appropriation? What is your response to Ms. Bussel's argument about that money being insufficient to satisfy, the statutory requirements of a school improvement fund or grant to essentially make whole the school district for those lost funds for the first 3 years of the program, given the amount and the dedication of some of those funds already to other portions of the program operations?
There is no proof in the record from that funding that the monies appropriated are insufficient to meet the grant funding for the program. And the letters that were sent out this week to the school boards notified the Metro Nashville Public Schools that of the intent to enroll forms submitted by students, there were 499 of them looking to enroll in the program. And for the Memphis Shelby County School District, that there were 1,372 students that are looking to enroll in the ESA program. Those numbers are under 3,000 students, which Metro submitted would the 29 million or whatever portion of that appropriation would support a grant fund for approximately 3,000 students. And also there, I would note to the court that their calculation is based on the ESA award plus 6%. And so whatever number they have put before the court is inaccurate, and it would be based on the ESA amount only. But there is no proof, clear proof in the record that those appropriations would not cover the grant funding for the program this year.
Does the program allow for students to join, to select ESA as an option after the school year has started? Which is sort of a timely question since we're the Friday before the start of school in both of these systems. Because Ms. Bussell seemed to imply that she thought students could, which made me wonder how the money would flow. So if somebody comes to a Shelby County school and stays in that school for 1 month or 2 months or 3 months, and then elects the opportunity to go to an ESA, to participate in the ESA program, is there going to be some sort of proration of that money? How's that going to work?
Yes, and that is provided under the statutes, that if the student is not in the ESA program for the full year, that the ESA amount would be prorated to reflect the number of days that that student was in the ESA program.
Okay, so that is in the statute. I guess I just haven't focused on that section. So that addresses certainly some of the plaintiff's concerns that by doing this so quickly, it has this effect of students having difficulty electing to participate at the beginning of school. But the proration, at least, it sounds like, is designed to even up the funding.
Yes, Your Honor, and I apologize for not having that statutory provision at hand, but I'll make sure to provide it for you.
You didn't know I was going to ask that question. Go ahead.
I'll make sure to find it before the end of the day, Your Honor. So due to my prior arguments and that the department has worked hard to implement this program, that there is a clear state interest to implementing this program as put forth in the statute, and that the plaintiffs complain of a loss of funding has not been clearly established. If you look at the harms on whether an injunction would cause a greater harm to the defendants or the plaintiffs, it would cause a greater harm to the defendants, and that element would support denying the motion for temporary injunction. And the last round is the public interest. This also weighs in favor of denying the motion for temporary injunction. The state did put forth an affidavit from Eve Carney, and she has supplied information to the court that since July 13th of 2022, there are students and their families who have notified the department that they have an interest in participating in the ESA program. There are families that have looked to participate in these programs since 2020. But if we look at 2022, over 2,000 families have expressed an interest to participate, and more than 80 schools have expressed an interest to provide educational opportunities to these students. And then the Department of Education put on its website a webinar for interested families so they could better understand the program and what would be required if they applied and participated. And that webinar was logged into by 1,735 viewers. So there has been a clear interest and intent to participate in the program shown in the short week that the injunction was lifted. And of course, 2 years of education is meaningful for a student. The opportunity of education in a school that their parent has determined is a better fit for that child is an invaluable interest. Students' loss of 1 year educational opportunity cannot be recouped, and so the public interest weighs in favor of allowing the program to continue to be implemented. I'm going to go back through a couple points just based on the arguments made today, and then I will conclude. In support of the claim for irreparable harm, what was put forth before the court this morning by the plaintiff county was the irreparable harm is to the LEAs who allegedly cannot do planning for this school year. That is, of course, to the LEAs and is not to the plaintiff counties. And the argument for the counties themselves was made that the counties incur this injury regardless of the timing for implementation of the program. That the counties will always be harmed whenever this program is implemented. So they have not made a case or provided clear evidence that the county plaintiffs themselves will incur irreparable harm. In addition, what has been put before the court, if the court considers the LEAs, although we submit that that is not relevant and does not establish any harm to the plaintiff counties, but if you look at the LEAs, the funding from the BEP amount, this is put forth in the affidavit of the declaration filed by the plaintiff county, that is a monthly, that is done on a monthly basis. And so if and when the ESA program is implemented, any withdrawal of money will be done on a monthly basis throughout the school year through April of 2023. And so the LEAs do have time to plan for the program. It's not as if one lump sum will be taken in September and in August. They do have a way to plan for the program, and the monies that will be withheld are done on a monthly basis. And then, of course, in addition to that, the state will be making the grant funding available to them so that they are not harmed fiscally due to implementation of the ESA program. The plaintiff counties today stated that for ripeness, that it only requires a present controversy, which they say is established here. But that is not, of course, the law. And a claim is not ripe if it involves uncertain or contingent future events that may or may not occur. Respectfully submit any of the harms they allege caused by the ESA program are uncertain, are contingent, and they may or may not occur, and so this controversy is not right. With regard to the plaintiff county's argument that the Tennessee Supreme Court established that they have a constitutionally protected interest in the local control of local affairs, this is not established by the Tennessee Supreme Court in its opinion. They looked at this when they considered whether the plaintiff counties had standing under the Home Rule Amendment. They did not.
I'm sorry, under what?
Under the Home Rule Amendment, Your Honor. So this discussion of whether they have an interest in local control of local affairs is contained in the Supreme Court's analysis of the plaintiff county's standing under the Home Rule Amendment. They did not say that this interest has been infringed, as the plaintiff county is alleged today. They didn't look to the merits of the claim. They just said if the plaintiff county's alleged infringement to the local control of local affairs, they have standing. So this does not establish that they have an interest that has been infringed on here or before the court, in this case, when it looks to the equal protection argument. Once again, I think multiple times the plaintiff counties argued that the injury to them was the state taking millions of dollars from them. This is not clearly established in the evidence put forth in support of the temporary injunction motion. And finally, I'll just note that it's not necessary for the court to examine the legislative history. There's not a it's not appropriate or it's not necessary in determining the legal claims here. And even though plaintiff counties note, some legislators in the plaintiff counties did not vote for the program, respectfully, some legislators did in fact vote for the program that were in Shelby County and Davidson County. In conclusion, the plaintiffs failed to establish a likelihood of success on the merits. The affidavits they have filed and other evidence put before the court failed to establish irreparable injury. The defendants will incur more harm upon the issuance of an injunction than the plaintiff. The public interest is on the defendant's side, and allowing families this additional educational opportunity is a very important public interest. All the factors support the plaintiff's temporary injunction motion to be unequivocally denied. And if any doubt remains, it is incumbent upon this court to deny the motion based on the standards for temporary injunction motion. However, since all of plaintiff's arguments are based on an alleged financial loss, the injunction that the court would consider to be limited to funding of the ESA program and not additional implementation steps.
I'm sorry, the interference is really tough to understand.
Yes, Your Honor, I apologize. I don't believe it's coming from my end.
That was the court reporter, Ms. Bergmeyer, not any of the judges. And so I don't know where the interference is coming from. I'm muting every time I'm not speaking, so I don't know.
Okay. Well, if there's anything I could do to prevent it, I would. I think it's just the last point that Your Honors missed, but if not, please do let me know. The argument was that all the factors support denying the motion. However, because all of plaintiff's arguments are based on an alleged financial loss, any injunction that the court would consider should be limited to funding of the program and not any of the implementation steps of the program. Unless there's any further questions from Your Honors, we respectfully request that the plaintiff county's motion for temporary injunction be denied.
Thank you, Ms. Bergmeyer. And are we going to hear from Mr. Newsom now on the education amendment?
Yes, Your Honor. Thank you. By the way, can I? Okay. All right. Can you see me and can you hear me, Your Honor? We thank you for the indulgence that the panel has given us to allow to participate via Zoom. And good afternoon, Your Honors. May it please the court, for the record, I am Jim Newsom here on behalf of the state defendants. As Ms. Bergmeyer indicated, I am going to be addressing the arguments raised by the Mcewen plaintiffs. We respectfully submit that the plaintiffs' motion for temporary injunction must be denied. State defendants present 3 points in opposition to the Mcewen plaintiffs' temporary injunction. First, they do not demonstrate immediate irreparable injury. Their application for a temporary injunction failed. Second, their education clause interpretation is erroneous and not likely to succeed on the merits. Third, the Mcewen plaintiffs lack standing to assert a claim under the education clause. As the panel knows, there is no power, exercise of which requires greater.
Hold on.
Mr. Newsom, yes, the court reporter was indicating that you cut out, and I think you cut out a little bit too. I don't know if you need to be closer to your microphone or what. I know you feel like you're smashed up against the screen.
I'll do what I can, Your Honor, and just ask the court to let me know if my connection goes bad at some point. By the way, we will do that. I am you borrowing a computer because my laptop audio went out. So I'll just begin again. As the panel knows, there is no power, the exercise of which is more delicate, which requires greater caution, deliberation, and sound discretion, or is more dangerous in a doubtful case than the discretion of granting an injunction. The state defendants respectfully submit that the Mcewen plaintiffs are not entitled to the extraordinary relief that they request, a temporary injunction against the implementation or enforcement of the ESA Act. The injunction they seek includes, as they say, the use of state resources to process applications, engage with parents in schools, or to remit any funds in support of the program. As the Supreme Court held in this case on interlocutory review, this court previously erred by issuing an injunction that froze in place the state defendants against taking any steps in preparation toward the implementation of the ESA Act on the basis that the act violated the Tennessee Home Rule Amendment. The panel should not multiply the error by imposing a temporary injunction before trial based on the secondary arguments that the Mcewen plaintiffs now advance. Tennessee cases recognize that federal case law interpreting the federal rules of civil procedure as persuasive authority for purposes of construing parallel Tennessee rules. Controlling Sixth Circuit authority provides that a demonstration of immediate irreparable injury is indispensable for a party's entitlement to injunctive relief. In the absence of such a showing, a preliminary injunction or a temporary injunction in our case must be denied. Tennessee authorities agree. Injunctive relief will not be granted unless the injury is threatened or imminent and in all probability about to be inflicted. The Mcewen plaintiffs failed to demonstrate that they face immediate irreparable injury. The plaintiff isn't facing imminent and irreparable injury. There's no need to grant temporary injunction before trial as opposed to at the end of the lawsuit. There is no imminent and irreparable injury. The trial court need not consider the other factors for injunctive relief. A mere hypothetical threat, not an immediate irreparable injury that warrants the extraordinary remedy of a temporary merit. Temporary injunction, an injury must be both certain and immediate, not speculative or theoretical. Even if the panel were to conclude that a party is likely to succeed on the merits, we do not think the Mcewen plaintiffs should. That would not change things. If the plaintiff isn't facing imminent and irreparable injury, there's no need to. Now,
I'm sorry, you just dropped out. There's no need to.
If the plaintiff isn't facing imminent and irreparable injury, there's no need to grant relief now, as opposed to at the end of the lawsuit. Mcewen plaintiffs contend that the ESA Act subjects them to a loss or impairment of a constitutional right. They point out that the education clause of the Tennessee requires the state.
You just dropped out. I'm sorry.
Oh, I'll be happy to repeat it. Thank you. They point out that the education clause of the Tennessee Constitution requires the state to provide a system of free public schools. Constitutional right at issue is the right of school-aged children of the Mcewen plaintiffs to receive an education in their public schools. But the ESA right does not deprive the children of the Mcewen plaintiffs of their ability to attend free public schools in their counties of residence or impair them.
I'm sorry, you're completely dropping out. I'm not sure why.
Nor am I. I apologize. Constitutional right is the right of the school-aged children of the Mcewen plaintiffs to receive an education in their public schools. But the ESA Act does not deprive the children of the Mcewen plaintiffs their ability to attend free public schools in their counties of residence or impair their ability to do so. Moreover, during the 3-year period following initial program implementation, the school improvement grant under the Act will provide funding to their schools that will match any state funds schools would otherwise receive if they attended. So for now, Mcewen plaintiffs cannot point to any immediate, irreparable constitutional injury that they would suffer due to the implementation of the ESA Act, nor have they presented proof by affidavit that it would. The Mcewen plaintiffs also claim that they would suffer irreparable harm from the unlawful diversion of public funds from the purpose for which they were intended. But for taxpayers to show irreparable harm, the effect of the misappropriation of the funds must include the imposition of additional tax burdens upon the applicant for an injunction. In other words, it is not sufficient merely to show an illegal action on the part of state officials, but it is necessary to show that there is some increased burden of taxation likely result from the alleged legal exercise of power. The Mcewen plaintiffs failed to allege, much less demonstrate, that their tax burdens would increase if the ESA Act was implemented. And if they expect this panel to make a factual finding that their tax burden would be a direct result of implementation.
I'm sorry, you're completely dropped out again.
And if they expect, can you hear me now?
Yes, I can. I'm sorry. There is some background noise. I'm not sure why.
I hate to call someone out, but Chancellor Martin, your microphone is on.
It's not, I've been muting the courtroom microphone.
It doesn't appear that way on our screens, but I'll just
Well,
go
they
ahead.
can mute me on the system, but then they left me unmuted for about 40 minutes earlier, so I asked them not to do that. So I am muting in the courtroom. We are doing our best.
Thank you so much, Your Honor. The Mcewen plaintiffs failed to allege, much less demonstrate, that their tax burdens would increase if the ESA Act is implemented, and if they expect this panel to make a factual finding that their tax burden would be increased as a direct result of the implementation of the ESA Act, they would be required to present verified proof to that effect, which they have failed to do. Therefore, the Mcewen plaintiffs failed to demonstrate the implementation of the ESA Act for them to suffer immediate irreparable harm to their interests, taxpayers. Nor have they made demands or law, as they acknowledge. In fact, irreparable injury would occur in this matter if an injunction is granted against the implementation of the Act. Maryland versus King, Chief Justice Roberts stated that any time a state joined by a court for effectuating statutes acted by representatives, it suffers a form of irreparable injury.
Hey,
Mr. Newsom, hang on just one second.
They said in iron that there's feedback that's making sound.
All right, go ahead.
I was going to say, I can hear doors going, opening and closing and that sort of thing. So this court should not grant a temporary injunction against the implementation of the ESA Act because the people have an interest in the effectuation of the ESA Act that not overlook. The plaintiffs failed to demonstrate irreparable injury. Their motion for temporary injunction to be denied for that reason. Secondly, the plaintiff's interpretation of the Education Act is erroneous, failed on the merits. The Tennessee Constitution gives the General Assembly plenary authority over public schools. The Tennessee Constitution also grants the General Assembly the Education Clause obligates the General Assembly to exercise its legislative power to provide for the maintenance, support, and eligibility standards of a system of free public schools. Contrary to the view of the Mcewen plaintiffs, this provision serves an obligation for the exercise of legislative power, not on the legislative authority. The court in the small schools case, Small Schools 1, interprets the Education Clause as imposing that obligation, recognizes the legislature's discretion in accomplishing that obligation. The court stated that the Education Clause, quote, imposes on the General Assembly the obligation to maintain, support a system of free public schools, and that the means whereby that obligation is legislative prerogative. The High Court thus interprets the Education Clause as imposing an obligation on the General Assembly, but not a restriction on its authority. The Tennessee Supreme Court presumes that constitutional language is precisely chosen. In this very case, Chief Justice Page noted that the court's principles of constitutional construction include presumption of precision in language. The court presumes that constitutional language has been employed with sufficient to convey the intent of the people. Education
I'm sorry,
clause.
this is the court reporter. Judge, I don't think that the actual courtroom is muted because there are doors and stuff going on.
I understand that. I'm not sure. I'm beyond frustrated with the noise situation here, and I've sent some very clear texts to have that managed. So I apologize.
Thank you, Your
Words
Honor.
in his sentences, and I'm not quite sure what to do when that happens.
May I inquire of our court reporter how far I got before you weren't able to hear?
Well, it's just like it'll take out one important word in the middle of your sentence, and I wait to see if I can hear it, and it's so employed with sufficient, conveyed the intent of the people. That's sort of like how your sentence reads, because something took out the middle of your sentence.
Has the court any suggestions on how we?
How much more do you have, Mr. Newsom? I'm thinking a break might be in order anyway, but
sure.
I don't want to cut you off, but I want to make sure we get everything and find a natural place to take a break.
Why don't we do this? Why don't we go ahead and take a break right now? I'll pick up with the second point that I just began to make when we get back.
Judges, how long do you all want to take a break so that we can be ready to finish after we come back? What do you think?
I'm flexible. Do you want to do 10 minutes?
Why don't we do a 10-minute break? All right. So we'll take a 10-minute break and then we'll be back. Thank you all.
Thank you, Your Honor.
Court stands in recess.
Hey, Jim, can I?
Yeah, Chris.
I'm trying to be helpful. Can I suggest something? I could be totally off base. But I think the issue is your microphone is doing some suppression thing that's cutting your voice out. And there are
Mr. Wood, give me just a moment. I need to pause the Zoom before we handle this.
I'm sorry.
I'll gladly accept